Okay, I think we're ready to get started. Tim, if you can hit the record button, I think we will make sure this is working here. Good morning, everyone. I am Eric Lupher, the president of the Citizens Research Council of Michigan. I'd like to welcome you to the Citizens Research Council, our webinar on the 2 constitutional amendments on the November 2020 statewide ballot. The Citizens Research Council is a not-for-profit public affairs research group. This is the Research Council's 104th year of operation, a longevity we attribute to our promotion of sound public policy for state and local governments through accurate, independent, and objective research. We are a private, not-for-profit organization, and we rely on the charitable contributions of foundations, businesses, corporations, and individuals. I'd like to encourage all of you to join our circle of supporters and help us to continue to provide high-quality, independent information on important public policy topics in Michigan. If you value how this webinar and the associated papers contribute to the public discourse, and hope to keep the Citizens Research Council as an objective, independent, credible source of information into the next century, please consider a contribution. I want to let everyone know that we have put the handout files, the slide deck, on our event page for this webinar if you want to follow along. So you see it's crcmich.org, and up on the top there's a tab for events, and this will be the top one. You can see that, follow along there. Please note that we are recording this webinar and we will post it on our webpage where it'll be available for future viewing. So if you value what you heard and you want to share it with friends and colleagues, you can send them to our website, and again, it'll be on that event page where they can view this. I want to let everyone know that we have everyone but the presenters on mute, so we will not be able to hear you if you speak. To ask a question, please type them into the questions pane that appears on your screen as part of the GoToWebinar software. You can type these in at any time. We'll take the questions and respond to them at the end, but you don't have to wait to the end to type in your questions. And in fact, it would be helpful if you put them in earlier. Today's webinar is sponsored by Martin Waymeyer. Martin Waymeyer is a communications company, helps with strategic communications, social and digital media, issues management, and media relations. We are a big fan of theirs, and they're a steady supporter of the work we do. If you have any technical problems during the webinar, please let us know by calling 734-542-8001. After the webinar, you'll receive an email soliciting your feedback, and we'd very much appreciate any feedback you have. So why are we here? The papers that we published a week ago on the 2 ballot questions in this webinar continue the Research Council's long history of informing voters who are cast in the role of policymakers for the purpose of adopting constitutional amendments or approving initiatives and referenda. The Citizens Research Council does not take a position on these questions. Our role is to help you, the voters, understand the issues better and provide some context for you to consider your vote. Presenting today will be Craig Thiel, talking about Proposal 1. Craig joined the Research Council in 2006 and currently serves as the research director, but is also our primary researcher on educational matters and school finance. Before coming to the Citizens Research Council, Craig worked for the Senate Fiscal Agency for 6 years and for the House Fiscal Agency for 3 years. Previous to this time with the legislature, Craig held positions in the Michigan Department of State and the United States Environmental Protection Agency in Chicago. I will be dealing with Proposal 2. Again, I'm Eric Lupher, the president of the Citizens Research Council. I've been with the Research Council for more than 33 years now, spending most of my time as the staff expert on local government affairs. I became president in 2014 and have been steering the ship since then. So, because of our remote nature, we are going to be bouncing back and forth in remote locations where normally we would be in one place. And at this point, I hand it off to Craig Thiel to talk about Proposal 1.
There we go. There we go. I think the organizer had muted me, and now I have full control here. So I'm going to talk. All right. I believe I'm unmuted now. What is Proposal 1? As Eric mentioned, both of the questions have to deal with constitutional amendments. Proposal 1 deals with Article 9, Section 35 and 35A. Both of these are fairly technical, complex sections. 35 deals with the Michigan Natural Resources Trust Fund. This section was added to the Constitution in 1984. Section 35A deals with the Michigan State Parks Endowment Fund. This section was added in 1994. The legislature put the amendments on the ballot in 2008. That was through a 2/3 vote in both the House and Senate. So obviously at that time there was bipartisan support for these amendments. And they've been waiting for the next general election so voters can approve or disapprove. I should note that in addition to the constitutional changes that you're voting on, voters would also be triggering a number of statutory changes to the Natural Resources Environmental Protection Law that implement both the Natural Resources Trust Fund provisions in the Constitution and the State Park Endowment Fund provisions. The key issues that we're going to cover and we think are key for voters in deciding on Proposal 1 have to do with constitutional earmarking of revenues dedicated to the trust fund and the endowment fund and what happens with those earmarking provisions, and then also the use and sufficiency of funding for natural resources conservation recreational projects. Let's just go over a little background. I mentioned the trust fund was established in 1984 to receive oil and gas revenue from leases on state-owned property. I say oil and gas revenue leases, but it's any non-renewable resource that's extracted from state-owned property. So that would include oil and gas, natural gas, metal, non-metallic materials as well. But oil and gas generate the majority of the revenue annually flowing into the trust fund or the State Parks Endowment Fund. In 1984, this revenue stream was constitutionally protected and dedicated to environmental and conservation recreational purposes. Prior to 1984, a similar state fund had been established to receive this revenue stream, but over a course of a number of years, legislators had dipped into the fund to meet some budget challenges in the state spending plan. And so the effort was made to protect this from future legislative raids by putting it in the state constitution. The general principle behind the trust fund and the creation of it was to basically build up a principal balance that would then would not be able to be touched by state officials or either in the administration or in the legislative branch, and that corpus could not be spent, but it would spin off annual interest earnings from the investments. Over time, this corpus had been increased from 200 million to 500 million today. The Constitution also lays out how the money is to be spent. When the trust fund was receiving the annual revenue stream, 50% of that revenue could be used for approved expenditures, plus all of the interest earnings. When the $500 million principal cap corpus was established, only the interest earnings can be spent from the Natural Resources Trust Fund. That's because this revenue stream was then redirected to the State Park Endowment Fund, and I'll get into that in a second. There is a requirement in the Constitution that at least 25% of the annual funding must be spent on land acquisition, so this would be a floor in terms of the state acquiring additional land, so at least 25% of the annual revenue had to go for that purpose. And then a ceiling was established on the development of properties in the state at 25%. Since 1976, over 1.2 billion has been spent on Natural Resources Trust Fund projects. These have been spread across the state in every county. And again, the 500 million cap was reached in 2011, which then shifted the revenue flow from the trust fund over to the endowment fund. Initially, the creation of this endowment fund in 1994, it was set up to receive, much like the Natural Resources Trust Fund, a portion of the annual oil and gas revenues. Initially, it was 10 million a year until that trust fund hit its 500 million ceiling, and since then, the Constitution directs all of that revenue to the State Park Endowment Fund. The Constitution sets an $800 million cap. Again, this can't be spent, and right now, money is flowing in to that corpus, and it stands at about $283 million as of October last year. A straight line analysis suggests that the $800 million cap won't be reached for another 30 years. The spending provisions related to the endowment fund are different. The allowable uses are for the operations, maintenance, and capital improvements at Michigan State Parks. Similar to the trust fund, 50% of that annual revenue flowing in can be used for these projects, plus 100% of the interest earnings. And again, after this 800 million is reached, only the interest earnings would be spent. So that's where things stand right now. If you're thinking to yourself, this is a little bit of deja vu, and that you may have voted on this before, you are correct. This is a timeline condensed, looking at the changes, state constitutional changes to either the trust fund or the trust fund and the State Park Endowment Fund. So in 1976, the fund was created to receive the oil and gas revenue. In the late 70s, early 80s, there were these legislative raids that prompted Proposal B in 1984 to create the trust fund with a cap of 200 million. As the cap was growing, and it looked like there would be a continuation of revenues flowing in. In 1994, it was decided to raise that cap to 400 million, but also create a contingency that when that cap was reached, that the flow of revenue would continue to go towards other conservation, environmental, recreational purposes, and that was prompted the creation of the State Park Endowment Fund with this 800 million cap. And then you had a chance to vote again in 2002 to increase the natural resources cap from 400 to 500 million. And today, or I should say in November, you'll be presented with what is the fourth amendments or series of amendments to this section of the Constitution. Again, that would eliminate the trust fund cap, direct the future oil and gas revenues to the State Park Endowment Fund. So here are the key provisions related to Proposal 1. It would eliminate the Natural Resources Trust Fund's $500 million cap. This is necessary to allow future revenues to flow back into the Natural Resources Trust Fund once the State Park Endowment Fund reaches its 800 million cap. Again, that is scheduled to occur sometime it's not a matter of years, but a matter of decades, using a straight line analysis somewhere in the 2050s, 2060s. It would also allow the Natural Resources Trust Fund in earnings to be spent on a new category of projects. Currently, the projects are limited to land acquisition and development. This proposal expands the definition of development to include renovation and redevelopment. It would also involve a change in what is currently a funding ceiling in terms of money going towards development projects of public recreational facilities. That 25% annual limit would change to a funding floor similar to what is in place for the acquisition spending provision in the Constitution. So we would now have two funding floors that at least 25% of the money has to go to acquisition and 25% to development. It doesn't prescribe the mix any more than that. And then once the trust fund is receiving this oil and gas revenue again in the future, similar to what existed before it hit its $500 million cap, the trust fund would be able to spend up to 50% of the revenue coming in addition to all of the interest earnings. And I should just comment that the way this funding works is the Natural Resources Trust Fund Board approves the projects, the funding. Those are then, those recommendations are made to the legislature, who must appropriate the money before they can be spent. The legislature isn't involved directly in the selection of projects. This is under the purview of the trust fund board, but the legislature has to appropriate the money before it can be spent. There's another change having to do with the administration of the endowment fund. Currently, that's not a permissible use under Section 35A, so that would be added. And then there would be a new funding floor established for the State Park Endowment Fund to require that 20% of the money each year has to be spent on capital improvements at Michigan state parks. So the issues to consider, as I highlighted earlier, have to do with the concept of constitutional earmarking. That's one of the issues. And so just to kind of get out of the wonky language of earmarking, I'll just kind of do some definitions here. What is it? It's generally used as a method to reserve a certain revenue stream, a public revenue stream, and dedicate those revenues for a specific purpose. This can either happen in the form of a fixed dollar amount or fixed percentage. And we have throughout the Constitution a number of earmarking provisions. All of our transportation funding, gasoline, diesel fuel, and vehicle registration revenues that the state collects are all deposited into the Michigan Transportation Fund, and then the Michigan Transportation Fund can only be used for transportation purposes. We have earmarked a portion of the sales tax to the school aid fund, and the school aid fund can only be used for K through 12 education, higher education, and funding the state retirement system, the school retirement system. So this isn't the only provision in the Constitution where there is earmarking. There's a number of places. Usually the arguments in support of earmarking center on these three. The benefit principle. The benefit principle basically says earmarking is appropriate when those who are benefiting most from a government service are the ones who are responsible for paying for this. And so we can think of the transportation earmarking provisions fit nicely into this category. People who use the roads, use the highway system should pay for that, and they do so through registering their vehicles and then paying for gasoline and fuel. Another argument is earmarking can provide a minimum funding level to make sure that a certain priority is funded. It fixes it in either in statute or in the Constitution that a service will receive a specific either dollar amount or a percentage of a revenue stream, and that's guaranteed. And then obviously if you want to gain political support for a specific government service, you would support earmarking for a certain revenue stream to support that service, to ensure that that service is protected in the annual budget making decisions. So that really leads to what one of the key arguments against earmarking is which is it ties the hands of policymakers, budget decision makers, in that it takes resources, state resources in this case, off the table, regardless of the need in those program priority areas, largely to the detriment of other funding needs that the government may face. And I should point out that just because you're earmarking funding for a specific purpose program doesn't guarantee that the revenues that are flowing to it that are not earmarked, or flowing to that service that are not earmarked, will be maintained. So if decision makers decide that all that they want to provide for a given service or program is the earmarked revenues, they may pull back the discretionary revenues. So there's no guarantee that full funding of a program will occur even if there's earmarking available, or even if earmarking's at play. So as it relates to the earmarking provision in Proposal 1, as I've mentioned, the oil and gas revenue right now, once the caps are hit in the trust fund, which has occurred, and then the State Parks Endowment Fund, that revenue would go to the state general fund. This provision has been in the law since 1994, so through the amendments in 2002, the plan was always to send the money to the general fund after these caps were created. In fact, in the original constitutional language that was approved in 1984, there was no mention of the money going to the general fund. So it was just understood that the money, once the cap for the trust fund was achieved, would go to the general fund. It wasn't till the amendments were put in place in 1994 that it made it clear that the revenue would flow to the general fund once the caps are hit. Some of the decisions, considerations that voters might want to consider is, with this cap and moving the money back into the trust fund after the endowment fund hits its $800 million cap, is, we have 30 years until this is really an issue. Why are we doing this today? There's going to be other general elections between now and then. We have no idea what the state of Michigan's priorities are going to be in 20, 30 years. Will those resources be needed for another purpose? And similarly, we don't know what the state of the budget will be in 2050. And I should note that if it's decided in the future that maybe we don't want the money to continue to go to the trust fund, and we would like it to go back into the general fund. This is going to require another vote of the electorate. Another issue to consider has to do with the expanded use of the Natural Resources Trust Fund. Again, we're being asked to approve both a change in the use as well as the allocation. So voters are going to expand to renovation and redevelopment projects that are available. So this is likely going to increase the lot of potential projects as well as funding for those projects. And it opens up existing projects and those that have been developed with trust fund money to be maintained, capital improvements to prevent further deterioration. So basically putting money into projects that had been purchased or built with trust fund money, as opposed to letting those just deteriorate or having some other non-state funding pick up the needed capital improvements. And then finally, we have this change in the mix of project funding from a ceiling to a floor to require that development projects receive at least the same amount of money in the annual selection of projects as the acquisition projects. So in the end, this will provide the Natural Resources Trust Fund more discretion in selecting projects. So the bottom line, if this proposal is adopted, the $500 million cap for the trust fund goes away. That doesn't mean it starts receiving money right away. What it does mean is that when the $800 million cap for the endowment fund is reached in sometime in 2050, that the money would not flow to the state general fund, it would go back to the trust fund. And that the legislature would, as is the case now in terms of appropriating resources from both of these sources, would be able to appropriate up to 50% in the oil and gas revenue for trust fund projects specifically. If it's rejected, well, obviously we continue the status quo, which is the State Park Endowment Fund continues to receive this revenue. And then when that $800 million cap is reached, the money flows to the general fund. In both cases, if it's rejected, the annual interest earnings on both funds would continue to be available for legislative appropriation. And I believe that's the end of proposal one, and we'll hold for questions till the end. So thank you.
So yeah, that's a nice summary, and I think having that first really provide. There we go. Yeah, thanks, Craig. And I think having that come first really provides context for proposal two, where the proposal one, it took 7 bullets to go through the highlights of the software keeps wanting to mute me. All right. Let me cut to the chase here. Proposal one took 7 bullets to highlight what's going to change between the current situation and if proposal one is adopted. Proposal two is pretty cut and dry. As I said in my introduction, we don't take a position on these questions. We try to lay it out, explain what they are, and explain some things to think about. Sometimes that is sort of a pros and cons, and you want to have them even. As I began to research this and look back at the legislative history, the whole question of who's against this really jumped to the forefront, and it's really difficult to say why this is a bad idea. It's a question of what would change more than is it a good idea or a bad idea. So what is it? Proposal 2 is a legislatively proposed constitutional amendment that would add the terms electronic data and electronic communications to existing protections against unreasonable government search and seizure. More specifically, you can see here in the slide that Article 1, Section 11 of the Michigan Constitution would be amended. It would do a little cleanup by striking the word and then it would add in 2 different places electronic data and electronic communications, or to access electronic data or electronic communication. So the idea that your person, your houses, your papers, your possessions, and now your electronic data and communications would be secure from unreasonable search and seizure, and no warrant to search any place or to seize any person or things or to access electronic data or communications shall issue without describing them or without probable cause supported by oath or affirmation. It goes on, you can read our paper about what comes after that and the issues related to that. Again, this was placed on the ballot by the Michigan legislature a year ago, and that means that the next general election is when we vote on it, and that is either by absentee ballot now or at the ballot place on November 3rd. So you might ask yourself, this kind of sounds familiar. Why are we talking about unreasonable search and seizure in the Michigan Constitution? I thought that was all contained in the U.S. Bill of Rights. And you're right, it appears in both places. In Article 1 of our state constitution, that article is titled the Declaration of Rights, and it provides basic individual liberties that the state government shall not impair. And many of those individual liberties were modeled after those found in the federal Bill of Rights. So if you pull them up side by side, you can go through and you can see that both accord the right to equal protection of the laws, peaceful assembly, religious worship, freedom of expression, and freedom of the press. Both prohibit the depriving a person of life, liberty, or property without due process of law. Both provide the right to be secure in your person's houses, papers, and effects. I know most of you have memorized the Bill of Rights, but I put it up here just to remind you that it pretty much says the same thing, where Article 1, Section 11 refers to the person's houses, papers, and possessions. The Bill of Rights refers to person's houses, papers, and effects. But the words are a little bit different. Again, the Bill of Rights was written more than 200 years ago. Article 1 written in 1962. We voted on it in 63. So the language is a little bit newer, but it says the same thing. So why have both? That's a fundamental question that you might want to ask. The reasons sort of go back to the nature of constitutional federalism, that we would have the federal constitution and the state constitutions. And if you've read your history books or watched movies on history, you'll understand that in the early stages there was some conflict, some difference of opinion on how the federal constitution applied to the states. So most states have this Declaration of Rights in their state constitutions, and it's only really in modern history, within the last several decades, that the federal constitution and those Bill of Rights really are understood to apply to states and federal law equally. Of course, we write state laws. We have our own state constitution, and interpretation of that rests with our state Supreme Court. So we want to make sure, as the state Supreme Court interprets those things, it can rely on the state constitution. And states, when they're putting these types of things in, can go above the rights of the U.S. Bill of Rights but they can never diminish that. So here we see an example of that, where they're trying to go a step beyond what's in the U.S. Bill of Rights to provide some extra protections. We couldn't as a state say, we think that's silly, we don't want to do that. We have to at least abide by what's in the U.S. Bill of Rights. And why have both? Well, here we see, as constitutional scholars interpret constitutional law and the question of originalism versus modern day context. Technology clearly is evolving and has become part of our everyday lives. So how does it fit in? I'd make the case that in 1963, when our state constitution was being drafted, they had no idea the role that the technology would play, let alone if you were to think about it more than 200 years ago. So this provides the opportunity, by having it in both places, to adapt to the modern context, at least as it applies to state law and the state constitution. So it requires a warrant. What is a warrant? It is a process for law enforcement to ask permission to perform searches and seize property. The basics of it are that they must be filed in good faith by law enforcement officers. They must be based on reliable information showing probable cause to search. And, if you've watched CSI or Law and Order or any of those things, there's provisions that apply to what's considered reliable information and how was that reliable information obtained. But nevertheless, that's the basics of it. It must be issued by a neutral and detached magistrate, and it must state specifically the place to be searched and the items to be seized. And that's really what applies to the question before us. Should the law enforcement, when asking to obtain a warrant, be specific as to the electronic communications, electronic data it hopes to look at, and they must lay that out. Begs the next question: what is electronic data and communications? I think, right at the outset, when you say the words electronic communications, you can imagine email and text messages and the many iterations of that, whether it is through your phone or through some separate app that lets you communicate, Google Hangouts, or the many different iterations of that. Clearly electronic communications. Electronic data, right away the mind goes to the word processing, the spreadsheets, the pictures you might have on your phone. A lot of people keep their personal accounting, their checkbook, either on their phone or their PC or laptop or whatever. So similar files and images, right away the mind goes to that. But the chronicles of law enforcement in seeking electronic data and communications, they've gone in asking for telephone call records. So has communication gone on between the suspect and the victim, or have the co-conspirators, the suspected co-conspirators, been talking to each other, and are you able to trace that communication? Participation in online chat rooms, again, doesn't immediately fit maybe into the ideas of text messaging and communications, but here's a form of communicating back and forth, maybe less used today than it has, sort of back in base and some of that, but nevertheless still exist, and there's still opportunities for that. Looking at internet search histories is something that we see going on. So if I'm suspected of a crime, they might want to look at my internet search history. Did I ask Google, how do you make a noose? Did I ask Google, how do you hide property and clean so that the DNA is erased from things, and that type of thing? That would, it's some sort of evidence that could tie me to this, what the police understood happened to the victim, or the crime that was committed. The IP addresses, where was I, you know, where was I connecting to the internet? How is that connected? And that's the same thing, location data. So your phone is pinging off of the towers. There, you know, Google always knows where I am. The other communications devices out there with your cell phones, they know where you are. So if the police can look at that location data and know that at a time and place you were where a crime happened to be committed, that doesn't prove that you committed it, but there's one step further to say, no, you weren't at your uncle's house in Sheboygan, you were where this crime happened, and now you have to answer for yourself. Also, the time and length of use of individual apps, again, doesn't necessarily prove that you committed a crime, but shows that you are doing things that maybe relate to how the crime was committed or an event to cover it up or things like that. So when you think about electronic data and communications, it goes far beyond what immediately jumps to mind when you start thinking about these terms. And again, I would stop you. So in 1963, when we were adopting our current state constitution, who would have thought of these terms of IP addresses and the location data and search histories, all this type of, it was just alien ideas to them at that time. So here we sit in 2020. Do we have any idea what technology will look like in 2030, 40, 2050? 30 years down the road, we know technology's ever evolving. And so how does that play out as we think about these types of things? This is not the first time that either a state or at the federal level, these sort of issues have come before law enforcement and the criminal justice system. While the Fourth Amendment of the Bill of Rights does not stipulate the electronic property, electronic data or communications, it has been considered an effect in the language of that amendment. And it's ever evolving. Cases come before the different courts, and a few have made it to the U.S. Supreme Court. Usually landing, not all the time I get, usually landing on the side of protecting the privacy of individuals, treating it as an effect and therefore requiring a warrant. There are some federal laws that have been written, the pen registers, and trap and trace device statute restricts law enforcement from collecting the metadata concerning telephone, internet communication. So they don't know what was said on the phone call or internet communications, but they can establish that there was communication between two parties if they do that, and this law restricts that. The Electronic Communications Privacy Act protects email and other subscriber data stored by internet service providers from disclosure without appropriate warrants. So as you think about, they might not be able to get it off my phone, but can they go to AT&T or T-Mobile or whatever and try to get that data? Or today you think about how much information exists in the cloud. Can they go to them and get it? So there's been some effort to head off those sort of using the side door or taking the information in a different way. Clearly, amending the Constitution to put this in would benefit everyone. Anybody who uses electronic data or communications would enjoy this protection. As we thought about it, we think there's a few maybe that stand to benefit right away. So the governments, law enforcement exists in the context of cities, villages, townships, counties, and in fact the state government. So anytime they have to go through the process of solving a crime and they need to do search and seizure, if there's a question on obtaining that data without a warrant, they might be subject to lawsuit. If we can create clarity that that warrant is required, maybe that heads off lawsuits. That saves money for those governments and legal costs in defending the actions of the officers. And on the other side, if the person feels violated with the search and seizure that occurred, they might file suit to prohibit that or defend themselves with the allegations made against them. We know how it works. The more money you have, the easier it is to defend yourself, and those without the means are either at the mercy of a public defender or have to live with it because they can't afford a lawyer. So if we can head that off, that provides equity, provides justice for everyone. Michigan's not the first state to deal with this. As we were doing our research, we came across the NCSL, I guess it was, identified 12 different states that have constitutional protections. The ones in yellow, I marked in yellow because as I went to their state constitutions, it isn't as overt as it would be in the Michigan Constitution, but they have added data mostly about privacy, the electronic privacy. And California is a good example of that, not only as it pertains to law enforcement, but the allegations that Google or Amazon or the different things are listening to conversations and then gearing advertising to you, things like that. So those constitutions have built in that privacy. And oh, by the way, it applies to law enforcement and the requirement of warrants for search and seizure. Missouri is the state that comes closest to what we're doing. And you can see here their Article 1, Section 15 requires that all the people shall be secure in their persons, papers, homes, effects, and electronic communications and data for unreasonable searches and seizures and so on. I won't read the rest to you, but you can see there the similarity between what Missouri has done and what is being proposed in Michigan. So as you think about this question, I would say, is it a good idea? Well, as red-blooded Americans, we're used to the benefits of the Bill of Rights and Article 4 as it relates to search and seizure. But that's existed before this question now. And so law enforcement has been in the practice of erring on the side of seeking warrants so that they don't lose evidence. Anytime there's ambiguity, they're tending to go to seek a warrant. Does it happen 100% of the time? I couldn't get law enforcement to say that in my interviews of them, so I won't tell it to you now. But for the most part, it happens. As I said, technology is ever evolving, so what we understood today is different from what we understood even 10 or 20 years ago, and how will we understand it 10 or 20 years from now will be different. And as we think about putting this into our state constitution, how does that mesh with the federal Bill of Rights? It's okay for us to go beyond the federal protections, but we can never go below that. So this is one step beyond that. So I think much easier to understand than Proposal 1, but still important. And I don't think cut and dry that it necessarily requires everyone to vote the same way on this. I think people will interpret this in different ways and think about perhaps some of the future ramifications and how this might play into that. So Tim, let me advance to this last slide and encourage people to check out our website or follow us on social media. And I understand we've had a few questions come in.
Yeah, we've had quite a few questions come in, Eric, and I'm not sure if we're going to be able to get to all of them, but I would, promise our attendees that if we haven't answered your question while we're online for this webinar, we'll certainly reach out to you and can follow up and make sure we get to every question that we've received. One of the questions we've gotten from a few attendees, and this is for both you, Eric, and Craig, is some clarification for how this got on the ballot and who's responsible for that. So I think you said that, but if you want to reiterate how these constitutional amendments made it to the ballot.
Yeah, so why don't I take that? Michigan Constitution provides two paths to amending the Constitution. One is the one that maybe we're most familiar with because it's used with greater frequency, the idea that the people reserve to the right to themselves to draft an amendment to the Constitution and then circulate petitions to get people to agree that that's a good idea and we should move that forward. The other opportunity is for the legislature through a joint resolution to offer up a constitutional amendment and then with majorities in both chambers advance that to the Constitution, to the ballot. In both cases, nothing can happen unless the people vote in the affirmative. So neither the fact that a petition is circulated, nor the fact that a joint resolution comes out of the legislature advances the question to automatically amend the Constitution. Always the people have to vote on it to make that the law.
So here's a question for Craig. A few people have asked, could you comment a bit on the sustainability or predictability of fossil fuel revenues? What do those look like into the future?
Well, I'm not an oracle, so I can't really see into the future. I can note that this is a fairly volatile revenue stream. To accentuate that point, if we go back to 2009 or 2010, before the trust fund had hit its 500 million cap, there was a banner year for lease revenues coming into the trust fund. I think the number was upwards of $170 million in lease revenue coming in, of which close to over 100 million was dedicated to the Michigan Natural Resources Trust Fund that year. That was followed up the next year by the amount of revenue coming in, which I think was about, a fifth, a sixth that amount. So you can see some wide variation year to year. I would point out, however, that the design of both of these funds, setting them up as permanent funds whereby the revenue goes into the trust fund corpus, and then that corpus spins off interest earnings to support projects, that's set up in perpetuity to produce interest earnings to sustain the program. So I think there's two issues here. One is the actual revenue stream that builds the corpus. And as we noticed, the trust funds hit its number, and the endowment fund is about a third of the way there, with an estimation that it won't reach its limit for another 30 years. But even when those caps are hit, and if the revenue dries up on that day, both funds would be kicking off interest earnings to support projects, allowable projects.
Here's another question for Craig. Is information available, or do you know how current spending breaks down in terms of land acquisition versus various other projects, and what sort of development projects have been funded in the past or would be funded in the future? What does that entail in terms of that change or clarification?
Well, from an operational standpoint, I really don't see any changes. The Department of Natural Resources that runs this program for the trust fund has a application process in place. I don't pretend to be an expert on that, but it is available on the website, on their website, that speaks to how that process works. I'd also point out that the Trust Fund Board produces an annual report for public consumption that looks at the grant awards for the previous year, as well as looking at what's happened over time. It talks to the number of applications that have been received, those that received funding, and those that didn't. So those annual reports are also available on the Natural Resources, State Natural Resources Department website.
Here's a question for Eric. Can you differentiate or explain how electronic communications are different from things that have existed for a longer time, like a landline telephone?
Well, yeah. In either case, if police wanted to tap a phone, listen in on communications, they would have to seek a warrant, or even under federal law, if they wanted to get the information on a landline, who were the outgoing and incoming calls between, they would have to get a warrant for that information. And so now, under this proposed amendment, it would extend to the electronic communications, whether that's the cell phone or your computer or any other device. To get technical, sort of phraseology a little bit, they use the terms metadata and content. So when you think about a list of all the calls that were made incoming and outgoing, that would be the metadata. You don't know what was said in those calls. You can only establish that communications took place, and the content is knowing exactly what was said. So that would require the tap on the phone. And here you would need the warrant to actually look at the files, to look at the text, communication back and forth, and that type of thing. So the technology is evolving, but the basic issues are remaining the same. And the practice has been to get a warrant in either case based on statutory direction and case law handed down by the state and federal courts.
We've got another question for Craig here that a few people have asked similar questions, so I'm trying to group them together. In terms of funding in Prop 1, is this something where the legislature could stand in the way of approving funds or allocating funds for an approved project? And how could the governor's office be involved as well? What are the involvement for our legislative and executive branches of government?
Good question. The Trust Fund Board is created in this section of the Constitution, Section 35, Article 9, and it gives this authority, gives this body exclusive authority to determine which projects are eligible to receive funding, and therefore the legislature cannot mandate to this board what projects are put forward as eligible projects. The board has the complete discretion to recommend the projects to be funded, obviously subject to the limitations in the section dealing with the breakout between development acquisition as well as the allowable uses. But the actual expenditure of dollars have to be backed by a state appropriation. So, the legislature has to appropriate the funds before they can be spent. They can decide not to appropriate money for the projects, and they won't be able to be spent. So there is an interplay between the two, but as far as the legislature inserting itself to select projects directly, that's not permitted under Section 35 of Article 9.
Well, it's looking at my clock, I think we've just hit 11, so we probably are running out of time, even though I've got quite a few questions left. Do you guys have any wrap-up words you'd like to share? And then I'll make sure we respond to these other questions offline.
We just thank everybody for tuning in. If you did pose one of those other questions, Craig and I will take the time to go through those and respond to you directly. And then if it's appropriate, maybe we'll post those on our on the events page as well, so others can benefit from the question you've asked and our response to that. We very much appreciate your time and attention to this today. And think about us as you have the opportunity to provide provide support for the institutions you support. You know, those that you benefit from. We're a 501c3 organization that can only do the work we do with your support.
The only thing I would add is I have made some attempt to answer questions that have come in between answering the questions you've posed, Tim. If any of those answers are not sufficient or you've got further questions, don't hesitate to reach out to me or Eric. Our emails can be accessed through the CRC website.
Thanks, everyone. Enjoy the rest of your day.